Good morning, this is Stuart Davidson, your friendly QS, and this week I've been talking about what we can do for you as a business, if you're a contractor or a subcontractor, to make yourself more available, more desirable, more recognisable to a client. So we represent, as a practice, we represent clients and developers, etc. And really it's around what we do and how we find our contractors for clients, etc., and procure the works. And I've been talking about what you can do, and I've put together this system, which is a starter system. What you can do now to start to put yourself ahead of the game and in front of clients going forward, and also how you can, even in this difficult time of this COVID virus, how you can begin to strive forward and thrive coming out of this as well. So the system was the starter system, and we talked about S, which is for sales and marketing, and how you can use your marketing to pre-qualify the projects and the clients that you want to work with, how you can use training to develop relationships with clients and inform clients of how you work, and how you can start to look at systems internally and training internally, and how that links to your sales and marketing and your relationship with clients. So today we're on A, and that's agreement. So this is going to be quite an interesting one, because a lot of agreements are up in the air at the moment, and it's quite a difficult time. I mean, even when you search and you speak to lawyers, etc., they'll pinpoint certain key pinch areas. But the thing is, it's all going to depend on what your particular contract is on your project. What contract are you contracting under? Are you under a traditional contract? Are you under a construction management contract? Are you contracted direct with the client? Are you on a prime cost contract? What are there any amendments to those? So there's lots and lots of different variables on each project, but the key, the ones that coming out is force majeure. As a client, has your client got right to suspend the works? Is he going to give you an extension of time? Can the contract be terminated? And these are all kind of things that may or may not be in your contract, but sometimes there's a high bar on trying to if you're one party looking at a termination, there's a high bar on that, so that can be quite difficult. The force majeure issue on relevant events can be quite difficult, particularly if it's not defined in detail. And payments as well. You know, there's payment clauses, and are you being paid? Have you drawn a line in the sand? There's some lawyers that are talking about different remedies under different clauses. And there's some lawyers that are saying, well, let's just let it lie and it's got to be a standstill. Let's interpret it as a standstill, and everything kind of shifts forward, and then we start from there. So there's lots and lots of different things we can think about. One of the things I think is probably important, though, is that you issue notices under your contracts. They're issued in the right manner, so that you've got those in place. Put a marker down and issue the notice in accordance with your contract. Some notices can be on email, some need to go to head office, but just put a marker down. It's not that we're all going to be, we'll know the outcome of a notice if it's under a relevant event, etc., but I would put it down as without, as a confidential in privity, really, in terms of confidential discussions around what you're putting in there. One of the things you can do, and if you're a developer or client, is getting your team together and consider something around a standstill agreement, which would be a separate agreement that sets out, it kind of will give you a block in time to think about how you might work with your supply chain or your contractor in agreeing the way forward. So there's got to be an agreement to agree a way forward. So that might give you time. So within that agreement, you could probably set out, what parts are legally binding, what are not legally binding, and whether you look at different types of different ways of setting up and moving forward. A standstill agreement is particularly important if you've got disputes going on at the moment, particularly if disputes are coming to the end of a limitation period. So a standstill agreement might get you that extra time to agree that. One of the key elements in there as well is, are we, everyone's going to be pressurised in terms of cash flow, etc. So within that, a standstill agreement, you might look at, an ongoing monitoring and assessment of your contractors or your ability or your employer's ability to continue and start up the project. If you're looking at something around, sometimes it might be better in certain instances to terminate an agreement, but that needs to be in mutual consent, because it's very, very difficult to bring that to fruition if it's one party going for the termination over the other party. So you can do certain mutual agreements within a standstill agreement. If you do agree by mutual agreement to terminate for the time being, and because it's moved on so far and the contract terms might want to be different in the future, you could do a termination with a MOU or an agreement, memorandum of agreement of understanding, that you will start up again and renegotiate a new contract in the future. So there's lots of kind of things you can do, but I think the main important things around agreements is communication, and keep things going, and keep talking between the parties. And if you can do an agreement, I would always recommend you get some expertise, a solicitor that's an expert in that field, to put something together for you. But it could be a collaborative way of dealing with a stand down period going forward. So nobody really knows. There's a lot of uncertainty around how these contracts are going to work under the circumstances, because you've got the government on one hand talking about sites should stay open, but that's not necessarily practicable. That means that it brings uncertainty around certain contract clauses. So the only real way around this is to come to mutual agreements. Now, it might be that you've got ongoing disputes, or you've got there are commercial pressures on each of the parties. So one of the things you might want to consider, being that you might have, one of the remedies in a contract could be adjudication. And adjudication is meant to be there as a quick remedy, although it's not always as quick as the contract makes out it should be. But in this downtime, adjudicators are going to be under a lot of pressure. Are they still operating? Are you going to get your adjudication sorted out? They're more expensive. They involve more parties, lawyers on both sides, expert witness on both sides. So one thing you might want to consider, if you have got parts of an agreement or a standstill agreement that you can't come to agreement on, is maybe appointing a mediator or looking at mediation. Now, the good thing about mediation is that the documents, etc., issued to a mediator is private and confidential, and that evidence, that information, can't be used in evidence in another court later, apart from a final solution or a final agreement. But mediation might be a quick and economic way of coming to a solution, and you can agree that the cost of the mediator could be shared. So that's one thing that you could do. You might want to also look at, in this downtime, things around insurances, bonds, these kind of things. Have you got some cover there? You might want to look at instigating additional credit support for the supply chain finance. If you're a developer, you might be looking at refinancing the scheme. So there's lots of different things that you can do, and there will be things that are going to affect your supply chain. It might be that some traditional contracts, and many traditional contracts, actually give ownership, passes ownership of the supply chain from the client to the contractor. Now, it might be in a standstill agreement. You could look at that. You could look at your contractor's status at this particular time, and it might be that the payment process might change from paying a contractor and then putting that responsibility of payment of the supply chain onto the contractor. It might be that you want to introduce something around direct investor to supply chain payments coming out of this. You'll also want to look in a standstill agreement around the costs of demobilisation, the cost of remobilisation. So all of these things can be talked about and set at one side to either standstill your contract and then start up again. It might be talking around how you issue an extension of time. Now, an extension of time, we just don't know how long this is going to carry on for. So we're not quite sure where we're going to pick up. Some employers might decide to put a date, at least contract's not at large and time's not at large, and the contract is there, and that can be adjusted at a later date. But certainly talking about agreements at this point in time is a good thing. I mean, you can use Skype and VoIP and email still, to thrash something. A Zoom meeting, organise a Zoom meeting with your supply chain or with your contractor, your employer, and really talk around how you're going to go forward, start planning. And I think after this, there'll be changes to contracts. Of course there will, but while we're in the middle of this, it's a matter of really being practicable, having agreements in place, and this might be a side agreement, a standstill agreement. Get legal advice on it. It shouldn't cost a huge amount of money. Share the cost. And if you need to get a mediator, get a mediator. But certainly plans need to be put in place, and I think it needs to be something more of an open book than we've been used to. And it might be a solution that covers costs, and profit might be dealt with in another way. There are other ways of doing things like integrated project delivery systems and alliance type agreements that could be put in place where you can ring fence profit. Everyone's getting paid net and open book in the interim. So there's lots and lots of creative ways you can look at starting up again. There might be equitable agreements, as I mentioned, insurance and insurance bonds that might be applicable at this particular time. So again, lots of things that you can look at, but certainly get some kind of agreement in place rather than letting things drift, rather than letting contracts become at large. And you can have, you can decide what parts of your agreement are legally binding, which are not legally binding. If it's to be confidential, what's the status of that agreement? And there are set ways of doing that and setting those out. And it's something that we can support with, and something I've been talking to our legal advisors on. And I think probably I get the sense that the majority of thought at the moment is leaning towards a kind of mediation, consensual agreement approach. But there will be those that want to test the principles out in court. Of course, there will be those that want to do that. But I think for the majority of cases, a practicable agreement would probably be the best route. So I would start planning and seeking advice at this point in time. Certainly carrying out upping your game in terms of your sales and marketing if you're in construction is something that sometimes companies tend to put to one side when there's a quiet period or when there's cash flow issues. But it's one thing that you really want to be stepping up, identifying your ideal clients and the niche market that you're working in, and looking how you can pre-qualify those clients and then make the agreements more suitable to you. If you're just starting out a contract, or if you've got a contract waiting to start, I think it's a good time to check your contract terms, make sure there's nothing in there that's going to be too much of a risk, or things that are ambiguous relating to the current situation. So my real thoughts on it is to keep communication going, see if you can get the heads of terms for a standstill agreement or a mutual agreement, how you're going to progress the project or how you're going to start the project up again. an agreement that sets out the status of your existing contract and other side agreements that you might want to put in place. So heads of terms, a good lawyer, solicitor or contract advisor could help you with setting out those terms, heads of terms from an agreement, what's the status of them, which parts are legally binding, which are not, what's the confidentiality status of that particular agreement. Would you want to get a mediator to be involved on monitoring? And if, for example, it's gone, we're going on and over the months and things are not changing, people's finances, company finances are under pressure, there might be options to preempt before. I know there's a lot of talk about insolvency laws and changes to that and directors' responsibilities, and it's all up in the air at the moment. But certainly you could look at the possibility of a standstill period for an accountant liquidator to actually monitor the situation whilst directors, if it's got to that point where things are gone from bad to worse and there's an insolvency issue. But rather than actually going insolvent, can you work together maybe to get the input from an accountant, from an insolvency accountant, not to in the traditional sense of liquidation, but could you introduce we're going to have before we start up again, we're going to have a 1 month monitoring period with an accountant, with someone with those skills to work on behalf of both parties to keep things going, to see what we can do to keep the contract solvent. And maybe it might be around what assets can we liquidate to keep things going. We can keep directors in control. So it's really in terms of using their skills and expertise, an insolvency practitioner, to keep things going rather than winding things up, because they're usually associated with winding companies up and distributing, protecting creditors. And of course, that's still the case. But I think maybe it might be an idea, if things have gone that far, maybe get them involved beforehand to see what can be done to keep projects solvent, because their skill sets could be very, very valuable at this particular time. So these are sort of things that you can do in agreements and contract agreements. So I hope this has been helpful. One other thing you could do is follow the advice on the Google and internet, particularly in the Construction Leadership Council. If you look up Construction Leadership Council, they've got the latest updates and thinking from a public sector perspective. They've issued some procurement notes as well, which is useful to look at. And so I think I would take this opportunity to start to think about your business, your sales and marketing. What can you do? What training can you put on online? That's the S and the T, the sales and the training, and the agreements. Start to think about what you can do to come to an amicable agreement, who you can get round you, the team you can get round you. So it could be a mediator, it could be an insolvency practitioner for prevention employed by both parties to prevent insolvency rather than mop up after insolvency, because their skills are invaluable. Can you get quantity surveyors involved, chartered surveyors involved to draw a line in the sand to look at the interpretation of the contracts? Can you set out in a side agreement the status of the existing contract and the standstill contract? What the privacy notices, what the privacy and confidentiality on those are, how you're going to start the project back up again. Do you need to look at refinancing? Can you look at supply chain funding? Can you look at switching the responsibility for payment from the contractor to the client and a direct investor to supply chain payments? So there's lots of different things that you can look at and be creative with and come to an agreement, draft up a heads of terms, draft up an agreement. At least you're not going to get a contract at large, which puts you in a more difficult position, because you'll end up having heads of terms agreed in court, which will be a lot more expensive. So if you can do it by mutual agreement now, get the right people and team around you, maybe that's something that you can look at. So hopefully there's some things to think about. Always get legal advice on your contracts, because there is a bit of a minefield at the moment, but try and look at a way in which you can mutually agree between the parties, and then get that reviewed, get that in place, so that it gives you the best chance of restarting after this this shutdown period. So this is Stuart Davidson, your friendly QS. Hope that's been helpful. Have a great day, keep safe, and I'll see you in the next video.